You make first.
I don't know there.
And that's exactly the point.
Of course, if he'd stayed in
Nobody
his
knows.
house.
But unfortunately, the quirk in this law is that George Zimmerman, the defendant, could have been the initial aggressor. But at that point, if he does nothing more, and suddenly Trayvon Martin becomes the aggressor, and George Zimmerman reasonably believes that his life is in danger, according to the stand your ground law, he's got the right to use deadly force, which he used.
Yeah, it's an NRA law, and the NRA's even backing off that law a little bit, isn't it?
Well, the problem with the law is, as Randy pointed it out, that you can actually commence this whole thing yourself. You can become the initial aggressor, which is what the government is going to say Zimmerman was, and it's going to depend on what the evidence shows, and still claim the protection of the law. Most statutes that permit self-defense, permit you to use force or violence to defend yourself, do not permit you to do so when you started the whole thing. This statute, untested until now, does permit you to use force and violence even if you started the whole confrontation.
Is the word reasonable in there anywhere?
Yes.
Reasonable force?
Yes. I don't know if the word reasonable is in the statute. Right, right. But your belief that the other person is about to inflict deadly force on you must be a reasonable belief. So in order for the jury to take this defense into account at the time of his trial, Mr. Zimmerman must present them a basis upon which they can come to the same conclusion that he did. If he fails to present that basis, the court won't let the testimony go in.